Everybody can come in. My name is Romy Jurado. I'm an attorney here in South Florida. My law firm is called Jurado and Farshin. We are a diverse law firm and we focus on different areas of law, and we serve as a resource to a lot of realtors here in South Florida. One of those areas of law that we focus is, of course, state planning. We do state planning, we do probate, we do litigation, immigration, real estate, we do closings all over the state of Florida. And we like to be very helpful and bring these classes to you so that it can help you grow your business, protect your family, protect your assets, and anything that comes with that. We're fully bilingual. Everybody in my staff speaks English and Spanish. I'm myself Peruvian, and I was born there, and then we speak Spanish fluently. So if you or your clients want to speak in the language that's, your mother tongue, Spanish, we're delighted to help you with that. All right, with that said, let me start by sharing my screen. I like to make my presentations interactive. So if you can please there's a Q&A button, and you can simply just type your questions there, and I will try to answer them as I do my presentation. I don't see that chat when I'm sharing my screen. So if you could please put the presentation in the Q&A, that would be helpful. For those of you that recently joined, again, my name is Romy Jurado. I'm an attorney here in Florida. The name of my firm is called Jurado and Farshin. And today we're gonna focus on state planning. Please put all of your questions in the Q&A and I'll answer as I go. Now I'll proceed to share my screen. Give me just 1 second. Oh, no. Okay, there we go. Jurado and Farshin is, again, the name of our firm. Today, we're going to focus on state planning issues. That's me. Everybody's going to get a copy of the presentation. I don't know if of the recording. It depends how the recording comes out, but maybe that too. And you're going to get some emails from me regarding some resources that may be available to you. So why do you need a state plan, right? So right now, with everything that's happened in COVID and everything that's going on, a lot of people didn't think about their state plan before, but now seeing all this death around us kind of made us think about it. It made me think about it, and I do this for a living. So, for example, why do you need a estate plan? To determine how your assets will be distributed upon death. That is very important. If you don't decide that now in your life, then the court will decide that for you. To protect your minor children by designating guardians. These are things that we don't think about. I recently had my daughter, she's 10 months now. And oh my God, what happens if I and my husband, for some reason, we're traveling and we die? Who's going to take care of my child? Who do I want to take care of my child? My sister, my mother-in-law, my father, I don't know. These are things that you need to think about. And then you can do that through state planning. You can designate a guardian. To avoid or lessen the risk of family disputes over assets. That is so important. If your family is missing you, the last thing you want is them fighting over who gets what. It could be a big fight, it could be a small fight. Litigation is expensive. So you want to have a state plan that addresses who gets what, how, that is extremely clear so that there's not going to be any questions upon your passing. To tell the court what you want to happen following your death. Very clear. If you don't tell the court what you want to happen, then guess what? They're going to decide for you. To ensure that the individuals you choose can make decisions on your behalf in case of incapacity or death. This actually happened with coronavirus, right? So a lot of single people out there, a lot of even married people, and they didn't name who they wanted to make decisions, whether through a durable power of attorney, which I'll explain now, to make financial decisions, or through a healthcare surrogate to make, medical decisions. And then basically nobody is able to make decisions. So you want to make sure that you address this in your state plan just to prevent against the worst that can happen, to lessen the damage of something bad happening. Because let's face it, and it's a horrible thing to think about, but it's reality. We're all going to die eventually. We all may become disabled at one point. So the best thing that we can do, since we can't stop it, is to plan for it. So that is what a state plan is, to plan for those things. All right, so it's important estate planning documents, things that we draft for you, that I've drafted for myself, documents that I think people should have include the last will and testament. That's the very basic, the will that says who gets what upon your death. You can have a revocable living trust, which allows you basically to govern your assets, even though you're not here anymore. And I'll go more into detail later. Advance directives such as living will and healthcare surrogates. So you let the world know, well, not the world, the doctors know what you want to happen, with your organs. Do you want to receive resuscitation? Do you not? Life-sustaining treatment. What do you want to happen? A HIPAA release, you release your medical records. Who do you want to have access to that? A durable power of attorney. So a lot of you may be familiar with a power of attorney, but in Florida, a power of attorney ceases to be in effect when the person becomes disabled. Okay, so if you have a regular power of attorney and it's not a durable power of attorney, then it ceases to be in effect when the person becomes disabled. Forming an LLC, a limited liability company, a corporation, could be a form of estate planning, because now you've taken those assets out of your personal assets and you put them in a company, and then the operating agreement can say what can happen to those things or to the company upon your death or passing. Maybe the company has the right to buy it from your state. They have the right to buy your interest from your state if you become disabled or if you pass, and therefore you took it out of the probate. And I'm going to explain that further in a minute. Pay on death accounts. I cannot stress this enough. Everybody here right now should go to their bank, not right now, after my presentation, and make sure that their personal accounts are set up to be payable upon death. To who? To whoever you want. Why? Because that takes it out of the probate state in case of death, and now your family, they don't have to wait for that probate to get started and conclude before they can use those funds. That is so incredibly important. We see this every day. I've seen it in my whole family. And even though I told them this is what you need to do, they still didn't do it. I cannot do it for them. I'm not in their bank account. But what happens is mom dies, and now their children are like, oh, I know mom had some money in the bank. We needed to pay for funeral expenses. But guess what? Mom is the only one in the account. And she never went to the bank to let the banker know, make this payable upon death to my children so they could access it. Payable upon death does not mean you've given it to your children or to your spouse or to whoever you want to give it to. It means that if you pass, they have access to the account automatically. Okay. Now, if you want to add them to your account as joint account holders, by all means, you can do that. But now they have rights even if you're alive. What I mean by pay on death is you're saying, if I pass, I want this to go to my children automatically without it having to go to probate. So now they have access to this account, and now they can use that for whatever they need during that very difficult time. So it's important. Joint ownership with rights of survivorship. You can take property as joint owners with rights of survivorship. What does that mean? If I own this property with my husband, which happens automatically, by the way, in Florida, for those of you that are married, you are taking property under something called tenancy by the entireties. So if my husband and I buy property as tenancy by the entireties, basically we both own 100% of the property at the same time. So if one of us goes to heaven, the other one automatically gets it. But you could also do that with friends or family. Let's say you have a friend and you want to buy a condominium. Well, now you can be tenants in common, meaning each of you owns 50-50, but that means that your 50 will go to your heirs and it will go through probate, or you can be joint tenants with rights of survivorship, which means whenever one of us dies, it automatically goes to the other. So that is an option that you can do when buying property. Life insurance. It's so important to have life insurance because you never know when that horrible time will happen. And you want to protect your family. And that life insurance doesn't go to probate. It's outside of the probate. It automatically, well, not automatically, it goes through a process, but it gets paid directly to whoever you've designated to receive your life insurance. Your life insurance can benefit your children. Your life insurance can benefit your spouse. Your life insurance can benefit your lover. It can benefit whoever you want it to benefit, your parents, your pets. So, you decide who, and you can change that too. So maybe right now you're like, oh, I wanted to go to my husband, but then you get mad at your husband, so you don't want it to go to him anymore. You could always change it with your insurance provider, but it's so important, life insurance. All right, I see I have a couple of questions. For those that recently joined in, again, my name is Romy Jurado. I'm an attorney here in South Florida. Please put all your questions in the Q&A because I do not see the chat when I'm sharing my screen, and I will answer as I go. All right, so somebody's asking, I have assets in the United States and outside the United States. Will the estate planning be able to include assets outside of the United States? Do you have knowledge of the law in some countries in Latin America where my assets might be? That's actually a great question, okay? So I'm a licensed Florida attorney, right? So I know the law in Florida. And if it's federal law, like immigration, trademarks, I know the law, federal law as well, all over the United States. But I'm not a licensed attorney in any other country. However, I can tell you what happens in Florida, right? So let's say somebody died in Peru, a Peruvian citizen dies in Peru, but they have property in Florida, title in their name. Well, a Peruvian probate, it's going to be open in Peru, but that judge doesn't have jurisdiction to determine what happens with the property in Florida. Therefore, an ancillary probate would still have to be open in Florida to determine what happens with the property in Florida. That is, if there was no estate planning, right? That's what will need to happen. However, if the property in Florida was placed on the LLC, if the property in Florida was placed on an irrevocable trust or a revocable trust, then there might be ways to eliminate the need to open the ancillary probate here in Florida, because this is a foreign national that lives in Peru and they don't want to deal with probate in Florida. Same thing for us. Let's say I have property in Peru, right? Or I have property in Colombia, Panama, wherever. What I would need to do is I would have to talk to an attorney in those countries and say, listen, I am a United States citizen or a permanent resident. I'm going to have all my estate planning done in the United States. I want to include this in my estate planning. Is there specific requirements that I need to comply with in order to include this asset? And they might tell you, I don't know, look, for the company, it's fine if you name it this way. However, for the property, because no judge will have jurisdiction over property in Peru or Colombia unless it's a Peruvian or Colombian judge, you will need to provide for that locally. You will need to figure that out locally. So every country is different. For example, in the United States, even if you die in New York and you live in New York all your life, if you have property in Florida in your name, you're going to have to open a probate in New York and an ancillary probate in Florida. That's the way it works, right? In other countries, I don't know, if you die in Lima, do you still have to open ancillary probate in another province of Peru? We don't know. There's too many countries, too many laws. Our systems are different. You know, here we are on common law, over there they're not. So what you want to do, absolutely, be a property in any other country, meet with both attorneys, an attorney in that country and an attorney in the United States, in the state where you reside. So Florida, for example, if it's here, so that we as attorneys can work together to accomplish the best state plan. If you want to avoid probate, for example, and you want to accomplish your goals, your wills, and also, whatever you want to accomplish, we can work together. I work with attorneys all over the world. Seriously, because clients now, we're all global. We have property all over the place. So you definitely want to plan for it. So that's the answer for that. Okay. What is the average cost for estate planning? That depends, because there's different kinds. There is a simple will that you might need, and maybe it costs you, I don't know, $1,200, $1,500. And then there is a big, revocable living trust that you can do, but maybe you want to do a family trust, for everybody. So then that costs more. But maybe you want to do a joint will for you and your spouse together because you have the same children, you want the same thing to happen. Maybe you want to still qualify for Medicaid, right? So Medicaid, Medicare, you still want to qualify for Medicaid. So then you do a irrevocable trust to take everything out of your estate. The estate planning, it just depends on the amount of assets, what your goal is, who your heirs are you a foreigner, not a foreigner? So prices can be all over the place. And you don't want to go somewhere that they tell you it's always going to be this, this, and this, because you just don't know. It depends on the assets that you have. So that's the answer for that one. Somebody else, can you add few people? I guess that's to your estate plan. Yes, you can add whoever you want. One cool thing that we have in Florida that I'll share, I'm a big animal lover, meow, meow, roof, roof. And in Florida, we're allowed to do something called pet trusts. So you can provide for your spouse, for your children, for your friends, but you can also provide for your pets. I have a nonprofit, it's called Attorneys at Paw. And through that nonprofit, we raise funds to spay and neuter homeless cats. And it's so sad when we see that a previous owned cat, had a nice owner, now becomes homeless. Why? Because sadly, the person didn't know they could provide for the cat. So what happens is the person dies, then the family goes, friends, whoever, they take all the assets and they take the little cat and put it in the shelter. That poor cat has been with that family member for like 10, 15 years, and now it's going to die in the shelter all alone, while the person, if you believe in heaven, is looking from heaven down there to the poor little cat that they owned and seeing how much they suffer. That doesn't have to happen. In Florida, we're allowed to do pet trusts. Through pet trust, you name a guardian, and you say, this person is going to be in charge of my cat, and they only get paid assets for the trust if they take care of the cat. You could also name a nonprofit to be the pet trust of your, to be the guardian of your cat. So they only get paid money from your state if they take care of your cat. When your cat passes, the money ceases. So that way you ensure that your pets, your cats, your dogs, your birds, whatever you have, bunnies are taken care of. So in Florida, we're allowed to do pet trust, and you can do that as part of your estate planning. And I highly advise you to do that because nobody will love your pets like you do when you go to heaven. I have seen it. All right. So that one is that. Let me answer the next one. Should a single person without children take life insurance? Yes, if you want to provide for somebody. Maybe you want to provide for your mom, for your dad, for whoever you want to provide. Also, talk to your insurance agent. But there are life insurance policies that increase in value, right? So that eventually, when you want, you can cash them out. So yes, a single person should have life insurance because you may be able to cash it out, live with that money eventually. There's all sorts of tools when it comes to life insurance. Talk to not one insurance person. Talk to a couple. Learn about the different types of life insurance. I don't sell life insurance. Otherwise, I will tell you all about it. But learn about the different types. It depends on your age, your health. See how it works. There's term life insurance that only works during a period of time. There's the other one that works forever. So just make sure that you fully understand and take advantage of it. It could be a great estate planning tool. It could be a great asset protection tool. And it could be a great savings for the future. 401ks, you can, for 401ks, you can also decide who will get your 401k, and you can change that at all times, right? So when my sister found out about my daughter, she was alive, she put my daughter in her 401k. So now that I'm gonna have another daughter, she'll probably put that one too. So you can decide at any time who you want to benefit from your 401k. It's a great tool because most employers, including us, we match. So that's basically a free salary increase that you've given yourself. Put that money away, get your employer to match, and just let that money grow. Can your primary home be under the name of an LLC? No. Why not? Because you want to get homestead status, right? So your primary home, in order to get homestead, it has to be titled in your individual name, or it can be titled under a revocable trust. Okay, so they will allow for you to still get homestead protection either in your name or in your revocable trust. Only those two. If you put it on an LLC, you will no longer get homestead exemption, and we all want homestead exemption because in Florida it's fabulous. So don't put it under an LLC. Can the estate plan be updated as you acquire or get rid of property? Yes, absolutely. You must. Many things happen. So draft your estate planning documents. They're not written on stone. Okay, so if something happens next year, something happens next month, have a good relationship with your attorney. Hopefully you'll pick me, but whoever you pick, make sure they're accessible. Make sure you understand what you're signing. My goodness, that's so important. I see that in estate planning. I also see that in business law, which is one of the things that I do. People sign contracts, 20-page contracts, and I ask them, so what does it say? And they cannot articulate what it says. Oh, the attorney did it. Who cares whether the attorney or whoever did it? If you don't understand what you're signing, it's not going to help you. Okay, so make sure you understand estate planning documents. It is so important for you to understand. Make sure that you share that information with whoever are your heirs, who's going to inherit from you. Say, look, this is the attorney that drafted the estate planning documents. This is what the documents say. This is where the originals are. This is where the assets are. It's not enough to have estate planning documents, right? You need to also educate the people that are going to get it from you, because otherwise they're going to be scrambling. Maybe they don't even know who has the will, and now everything goes to probate. It's something called per stirpes, and the judge decides who gets what. If the will is not brought to the probate, then nobody's going to know of its existence and its contents. So it's very important to, one, draft the documents with your attorney, but also educate your heirs and then update as you go. If you get divorced, if you want to provide for a new pet, for a new child, whatever it is, update your estate documents as you acquire new property, as you acquire new assets. Make sure your documents are updated. Okay, so it's not written in stone, and yes, definitely update them as you go. To the pay on death account. I'm not sure. Oh, to the pay on death account. Okay, you can add people to the pay on death account. Yes, you can go to the bank. Now, it's very important because I gave this class the other day and I told people, go to your bank and set your stuff payable upon death so that it can go through your heirs if that's your intent without having to go to probate. And somebody said, Romy, I did it. I went to the bank. I'm so happy. Thank you so much. And I said, okay, that's great. Did you verify that the account was updated? And she's like, what do you mean? And I'm like, did you see the document that says payable upon death, and do you have proof of it? No, I just told my banker. That's not enough. So you go to the bank, you let them know what you want, and you want to see proof. Even if they tell you it takes a couple of days, it doesn't matter. You don't rest until you see proof, because what's going to happen is when you pass, right? Oh, nobody finds the proof. Oh, it didn't happen. Sorry, it wasn't recorded appropriately. And now what? Now it's not payable upon death. So if you're going to set this up with everything that you do, make sure you have proof that it is, and make sure your heirs and whoever's going to get it has access to that proof. It is so important. Don't rely on people just telling you, I did it. That doesn't hold in the court. Unless you have a paper, a document from the bank saying it took place, it didn't happen. All right, let me go to the next slide and I'll keep on answering questions. Thank you so much for your questions. By the way, I keep on mentioning probate. Probate, what is probate, right? So for those of you that don't know or don't understand, probate is a court supervised process so what happens during this process is identifying and gathering the assets of the deceased person, right? Whoever went to heaven, paying the deceased debts, and distributing the deceased assets to his or her beneficiaries, either per the instruction in their will or per Florida law. So when you pass, everything goes to the state, not everything that's part of your probate state goes to your probate state. And then from there, whoever you owe money to, or your creditors, your student loans, the IRS, whoever it is, gets paid from that. So what most people want to do, and they try, is to limit that probate state. If you can take things out of that state, the better. How do we take things out? For example, payable upon death doesn't go to the probate state. Let's see what else. Insurance, life insurance doesn't go to your probate state. Things that are titled with rights of survivorship that automatically go to somebody else doesn't go to your probate state. Things that are in your revocable trust doesn't go to your probate state. So you see how we're limiting, so that your creditors are not going to be able to get everything from it, because you're limiting your probate state. It just so happens that you may have done really good estate planning. You took out everything out of your probate state, and now your creditors get nothing. How do we know that? Because they reach out to us. They're like, oh, we see you're the attorney of record for this probate. What's going to be in the probate state? Want to make a claim, and then there's nothing. Guess what? They get nothing. So planning is essential. You want to leave your stuff to your heirs. You don't want to leave it to your creditors necessarily. Unless you do, then by all means, feel free. All right, so that's what it is, what I mean by probate. That's the system, the court supervised system. All right, so non-probate assets. I just told you from my head, but here's the slide. Very important to know this. Real property held jointly as tenants by the entirety, or joint tenants with rights of survivorship. If you have ownership with your friend, lover, I don't know, whoever else, but it's not with rights of survivorship, then it's tenants in common, then it is subject to the probate state, whatever part of it you own. Assets titled in a revocable trust. I just told you that. Real property, bank accounts, brokerage accounts. If they're titled in your revocable trust, they're not part of your probate state. So that creditors will not get it. Now, it's not enough to do a revocable trust. Guess you have to transfer the assets to that trust. You have to fund the trust. People come to us and it's so sad. And they're like, well, here's the trust of my mom. And we're like, okay, that's fabulous. Where is the deed showing that this property was titled in that trust? Oh, she never did that. Where is the, the bank account that showed it was titled in the trust? Oh, she never did that either. And the brokerage account? No. Well, guess what? You have a trust that's empty and all the other stuff still subject to your probate state. So now the creditors can come after it. So it's important to do a revocable trust, but it's important to fund that trust. Otherwise, you just did the revocable trust for fun, not to fund, for fun. Survivorship bank accounts, I explained, payable upon death, very important. Life insurance, IRA, CE, or any asset with a beneficiary designation, so important. Exempt homestead, this is wonderful in Florida. That's why you don't want to put the property on the LLC, because homestead property that passes, okay, to a surviving spouse or heir is exempt from your probate state, right? So the creditors cannot catch it. So this is so important. Retirement accounts is also exempt from your probate state. So all this stuff, if you do it correctly, it's not going to be part of your probate state, and your creditors will not be able to catch it or get it or whatever to satisfy the debt. I'm not saying to go around getting a bunch of debt, but listen, if you're going to heaven, I think that, for you to rest in peace, you would want to provide for your heirs instead of paying off the creditors. That's just my view. All right, so let me keep on answering questions, and then I'll go back to the slides and keep on asking as many questions as you want. I don't even know what time it is, but if you have time, I'll have time. Okay, so it is more important about probate. It is more about probate than estate planning. We just started a probate process because my father passed away a couple months ago. The attorney sent us a petition to open an account under the state name to transfer all the funds from my father's account. Is this standard procedure? Okay, to whoever asked that question, I'm going to ask you to send me an email because we probably need to set up a consultation. You're right. That question is more about probate. And I need to have you speak with our probate attorney if you want to get a consultation regarding that. So send me an email so we can discuss, because this is not estate planning, which is what we're dealing with right now. This is the estate planning already took place, hopefully, and now you're at that step. Next question. If we have a few investment properties, would you recommend to open different LLCs for each investment property, or is it okay to keep all under one LLC? That's actually a really good question. So one of the reasons why people set up LLCs is for liability protection. So let's say that you own this apartment in Hollywood, Florida, right? And you bought it for investment purposes. So you're going to rent it either through Airbnb or yearly, however you want to do it. If that apartment is named in your name and somebody falls in that property, something happens in that property, there's mold in that property, there's some type of damage in that property, they're going to sue you personally, and they're going to be able to attach any and all assets that you own personally. We don't want that. If you put that property in the name of an LLC, then they can only sue the LLC, and assuming the LLC only owns that property, that's all they can get. If you put the property in the name of an LLC, and that LLC owns that property and this other property and this other property and this other property, now they're able to come after all those assets. So to answer your question, if your own investment property, is it better to use one property per LLC? Yes, because now you're really limiting your liability to just that one property. If you put a lot of properties in that LLC and one of the properties has a lawsuit, they're going to be able to come after all of those other properties. So you're basically making it really easy for them. So don't do that. Also, when it comes to LLC, I give another class about liability protection, but it's very important not to use the bank account as your piggy bank. A lot of people go form LLCs, form corporations, and then you look at their bank account and they're using it as their piggy bank. That is so easy for an attorney to show that you've commingled funds, that the LLC is a sham, and that they should pierce the corporate bail. And now you have no liability protection. So don't do that. Follow corporate formalities if you're forming LLCs, and don't use the bank as your piggy bank. I'm not saying don't get money from the LLC. No, get it the right way, either as a distribution or as salary. Don't get the bank and go pay for your hair and pay for your stuff unless you're an artist and that's part of your business. Okay, just simple advice on that. Upon death, is the surviving spouse liable for the decedent's personal debt? It depends. Did she co-sign the debt? If you signed, you're liable. If you didn't sign, then you may not be. So it's very important. I'll give you an example. My auntie passed away. She's in heaven now. And my uncle started receiving all of this mail for all this debt of all of this medical bills, like OMG, it was crazy. And he was, of course, dealing with the death and so sad. And I just said, just collect them all and bring them to me. Just collect them all and bring them to me. That's all I told him to do. And then I went, I read, I contacted the creditors. I asked for the loan for any documents that he signed, my auntie signed, because the truth is, it's not always a yes or always a no. Is you have to see and analyze each creditor and see, did the other spouse co-sign? Did they say that they would be financially responsible when they went and put the person in the hospital? For the credit cards, were they also an authorized user? Did they sign that they would be responsible for the debt? If it's a mortgage, I'm almost 100% sure the other spouse is going to be responsible, because guess what? They're going to be asked to sign the mortgage even though they're not part of it. So it's a question that it doesn't have a straight yes or no answer, even for personal debt. You have to see whether the other spouse co-signed the debt or agreed to be responsible. If they didn't, then I don't see how they can be responsible. Can a business account be put in a revocable trust? Yes. Can investment like stocks be put in a revocable trust? Absolutely. Yes, you can. You can name everything in revocable trust, and then that trust becomes irrevocable upon death only. So during your lifetime, you can be changing, adding, who do you want to get it? Who do you not want? And you can go that way. Very important. I've had many people want to disinherit children. That's fine. They're adult children. They want to disinherit them for one reason or another. That's not my business. But in order to properly do it, you have to name them as specific as possible. You have to name their name, the day they were born, where they were born, where they currently reside, if you know, because otherwise they will use that and say, no, they didn't really mean to disinherit me, to fight it. So if you're trying to disinherit somebody, be as specific as possible in your estate planning documents. Somebody's asking me something about a COVID vaccine and life insurance. I am not familiar about that. So you would need to read your policy and talk to the insurance provider. Yes, I'm going to be sharing the slides. I don't know about the recording of the webinar, but for sure the slides, it depends on how the webinar looks and if it records well. All right, so let's keep on talking. Last will and testament. So a will, like I told you, is the most basic and common estate planning tool. A will allows you to provide instructions on who inherits what. If you die and you have assets in your name, you will be dying what is called testate if you have a will. If you die without a will, it's going testate. If you die intestate, the court decides who gets what according to a process that's called pars terpes, okay? So what do you need to do a will in Florida? Very important. People can do wills in other countries, but in order for them to be valid in Florida or other states, they have to be done according to Florida law. So per Florida statute 732.501, any person who is of sound mind, so you cannot be disabled at the time that, you could be not mentally disabled at the time that you do the will, and you also need to be 18 or more years of age, or an emancipated minor can make a will. Okay, so it's so important, of sound mind. Most litigation goes under that. Was the person of sound mind, The will must be in writing and executed as per Florida statute. The testator, right, so this is the person that's doing the will, must sign the will at the end, not on top, not on the side, no, at the end of the will. The testator's name must be subscribed at the end of the will by some other person in the testator's presence and at the testator's direction. It must be signed in the presence of two witnesses, in the presence of the testator and in the presence of each other. So in other words, the person who's doing the will must be of sound mind. They must sign at the end of the will. They need to sign in the presence of two subscribing witnesses, and the two subscribing witnesses need to watch this person sign. They all can be together physically. The law recently changed where you're able to do wills remotely. I haven't done one yet because I'm a little scared. I'm waiting to see for other people to do them, and then seeing litigation that arises from it to see how to really do it so that it stands, the test of the court. Because it's like, I know with COVID and everything, it's a little weird. So I haven't done one yet, but it could be done according to Florida law. It could be done virtually. I just haven't done it yet. I'm waiting to see what happens. All right, so testate administration. If you die with a valid will, the role of the probate court is to distribute property according to the decedent's instruction in the will. Then they have to appoint a personal representative as indicated in the will. So in the will, you can say this person will be my personal representative, and they would be the ones in charge with the court to make sure that everything happens how the will is stated. Okay, you can name that person. For some reason, that person cannot serve or somebody else cannot serve, your alternative personal representative, then the court can also designate a personal representative. A will can nominate guardians for minor children. You can say, well, I have, this daughter and I want the guardian to be this person or this person. You can do that. A will can be used, as I told you, to disinherit specific individuals. I don't want this person to get anything from me. I don't want this other person. Be very specific if you plan to disinherit people. That's all I can tell you, because that's subject to a lot of litigation. What you cannot do with a will, you cannot devise the homestead, your homestead house, if you are survived by one or more minor children. So if you're survived by one or more minor children, you cannot disinherit those children from your homestead house. If you're survived by a spouse, but not minor children, assuming that there is no prenuptial or postnuptial agreement between you and your spouse, then you can devise the homestead outright to your spouse. You're allowed to do that. Okay, so there is no prenup, no postnup. You could devise the homestead outright to your spouse if there's no minor children. If there are minor children, then you cannot devise the homestead. Okay, and devise means give. You cannot give. So what happens in the unfortunate event that you go to heaven without a will? If you die without a will, the laws of intestacy dictate how your assets pass on death. Generally, under these laws, your surviving spouse is entitled to all your individually held assets if you do not have surviving descendants, or all surviving descendants are descendants of both you and your spouse, so you have shared children. A surviving spouse is entitled to 1/2 of the decedent's individually held assets if you have surviving descendants who are not descendants of your spouse. You and your spouse have surviving descendants jointly, and your surviving spouse also has descendants who are not your descendants. So in that instance, your surviving spouse only gets half. In the other instance, where all your surviving descendants are descendants of both you and your spouse, then your surviving spouse is entitled to all of it. So what if you do not provide for your spouse in your will, right? So you did your will, but you didn't provide for your spouse. Well, there's something called the elective share. So if the decedent spouse did not provide for the surviving spouse, or did not provide enough to the surviving spouse to meet the elective share requirements, the surviving spouse can take an elective share in the decedent's estate. The elective share is an amount equal to 30% of the decedent's elective estate. Unlike the intestate share, the elective share computation includes the value of assets other than those held in the decedent's individual name, including assets held in the decedent's revocable trust. So if you didn't provide for your spouse may still be protected. They can get the elective share of everything you have, even if you put it on the revocable trust. Pretermitted spouse. If the decedent spouse dies leaving a will made before marrying the surviving spouse that does not provide for the surviving spouse, that surviving spouse may be entitled to a pretermitted spouse share. The surviving spouse is entitled to a share of the decedent estate as a pretermitted spouse if the will was signed before the marriage, the spouse is not provided in the will, the spouse did not waive the surviving spouse rights, the will does not disclose an intention to exclude the spouse, and the pretermitted spouse share is equal to the spouse's intestate share. Okay, so these are things we analyze upon the person's death. Here is a little drawing of what happens, who gets what in intestate administration, meaning you died without a will. This is how the court says people are going to get your assets. All right, let me go back to answering some questions. Is it true? Oh, wait, we already said this one. I don't know. My husband bought a house, which is our primary residence, before we met and got married. So he is the only owner. What will be the best arrangement in order for the house not to go to probate in case something happens? So let's say your husband's name is Peter. The deed says Peter as a single man. I would have Peter deed the property to Peter and Juana, married as tenancy by the entireties. So now you took it from Peter as a single man and you gave it to you and your spouse as tenancy by the entireties. And if Peter dies or if you dies, it goes to the other person automatically. I would have that done. I wouldn't wait on that. It's very important because he bought this when he was alone. For tenancy by the entireties to work, you have to acquire the property jointly and be married when you do. The way to fix it is to change title from him individually to you and him as spouses. And now you're going to be protected. In case he passes, it automatically goes to you. In case you pass, it automatically goes to him. So change the title. This is something that we can help you with. Okay. If the person collects a disability check for mental illness, yet they have children they're caring for and maintaining with that check, can they not decide over their child or their assets? I don't understand that question. So I'm going to ask you to email me because I'm not sure I understand that question. Okay, so anybody asking me for costs, we do have a package and I can send you that information. Send me an email. I'll put my information in the chat so that we can help you, and we draft, durable power of attorneys, we do the will, we do the trust, everything that you need. So send me an email. What if the spouse is not on the property deed, only the children are on the deed? Can the spouse still get part of the property if there is no will? So if it's the homestead property, then the spouse will get it. But if the goal is to really protect that spouse, I would highly advise to put both spouses on the deed, but I have to see if the children is the children of both or just one. For this one, email me, send me the address or send me the deed if you have it, and then we can tell you how we can help you and fix it. Oh, okay, so I don't know if you guys got to see this, but basically your intestate succession is regulated by this statute. It goes to the surviving spouse, then surviving spouse with children from the decedent, and then if there is none of that, then spouse is entitled to take the entire estate. If there is surviving spouse but deceased had children from a prior marriage, then the spouse is entitled to take half the estate. Deceased children share the rest. If there is no surviving spouse, then it goes to the lineal descendants, such as kids, grandchildren, great-grandchildren. If there is none of that, then it goes to the parents of the deceased equally. If there is none of that, then it goes to the siblings per stirpes. If no siblings, then it goes to the paternal and maternal kindred, grandparents, aunts, uncles, etc. If none of that, then it goes to the kindred of the deceased spouse. And if none of that, it is cheats. So what does that mean? It means it goes to property that is cheats, must be sold, and the sale proceeds will be paid to the chief financial officer of the state of Florida and deposited in the state of Florida school fund. Okay, so if none of this, that's where it goes. So per stirpes, if you hear us say that, per stirpes is the method of distributing shares of estate. Each decedent is entitled to an equal share, and the share of a deceased descendant is divided equally among his descendants. And this is pretty much how it goes if there is no will. If there is a will or a trust, then you decide how it goes. So it won't be like this. The intestacy laws also provide an order for preference of who a personal representative is. A personal representative can also be compensated from the state. They don't have to work for free. You will name who you want to be your personal representative and the alternative personal representative in your will or your trust. But it will also be done this way if there is no will. So for an intestate state, the order of preference is the surviving spouse, then the person selected by a majority in interest of the heirs. Then if none of that, the heir in nearest degree or the best qualified heir as selected by the court. And if none of that, then any capable person appointed by the court. So this is how the personal representative will be chosen if you didn't name one in your will and if you didn't have a will. So who should consider a trust? A will states your instructions, but it does not avoid probate, okay? Assets held in irrevocable trust do not require probate administration. If you own property in other states, your family will probably have to open multiple probates and comply with the laws in that particular state, okay? Including other countries. to be private, right? So through this, you can be private. What I have done for clients abroad or U.S. clients that have property abroad is we do a U.S. trust and we name the property abroad in the name of the U.S. trust, assuming it complies with local law, which we need to verify with the attorney in those countries, and then it avoids probate. To be private, right? Because you don't want, your will gets probated, you know, it's kind of public, people can fight it. A trust is private, it's a private document. To manage and control spending and investments. I had a client once do a trust where they say, I love my spouse, but I don't want her to inherit everything outright because she has a casino problem. So I only want her to get paid this amount of money every often just to maintain her, you know, her status of living, but not extra, because if she gets extra, she's going to go use it and play it in the casino. That was his will, his desire. That's what he put in the trust. And that's what happened. And actually he was providing for the spouse. To manage, oh yeah, we already said this, to manage and control spending and investments, to protect beneficiaries because they are too young, disabled, or incapacitated, irresponsible. To manage and control investment and investment, we already said that. To set aside funds to support, to reduce income taxes from state and transfer taxes. I always like to work with your accountant, your CPA. We want to limit your tax exposure as much as we can, and I work together with your CPA in order to accomplish that. HIPAA release, for those of you that don't know what it is. A HIPAA release is an authorization that allows an adult or emancipated minor to authorize a healthcare provider to release protected health information to named third parties. In Florida, an individual may authorize the release of healthcare information to an agent by executing either a HIPAA release, an authorization form, or a Florida designation of healthcare surrogate, which is what we do. We do a healthcare surrogate form, and that way they're able to obtain that information. Another estate planning document is the living will and healthcare surrogate, which I just mentioned. Florida statutes now provide for a written declaration by an individual specifying directions as to the use of life prolonging procedures. Do you want to be put in the ventilator? Do you not? All those things you can put in your living will. Florida law also allows you to designate a person, that's your healthcare surrogate, to make healthcare decisions for you when you may not be able to do so. Included in this important appointment is the power to decide when to withdraw medical procedures. That is so important. You get to decide who makes that decision for you if you can't, because you know you're under a procedure. And it's really important, I think, because then it doesn't, like, people are not questioning each other. What do I do? What do I do? Is you make a decision, this is what I want to happen, or you make a decision, these are the people that I want to happen, that I want them to make a decision. Okay, so let's go to the next. Durable power of attorney, as I was telling you, if you have a regular power of attorney, it will not work. It has to be a durable power of attorney. For instance, if you're sick and in the hospital, like what happened with COVID, you cannot do banking, so you give power of attorney to your spouse, daughter, whoever you want to be able to pay your bills. When all these people were stuck in the hospital during COVID, nobody else could make financial decisions for them, do anything, because they didn't have a durable power of attorney. If they did, they were in luck and they were able to go to the bank and satisfy the bills. So a durable power of attorney is a writing that grants authority to an agent to act in the place of the principal, meaning the person that gives up durable power of attorney, whether or not the term is used in that writing. The document will assist the principal in handling his or her assets, paying bills after you are incapacitated. A principal, meaning you, may revoke a power of attorney by expressing the revocation in a subsequently executed power of attorney or other writing signed by the principal. The principal may give notice of the revocation to an agent who has accepted authority under the revoked power of attorney. Power of attorney is no longer valid after death of the principal. That is correct. You can give a durable power of attorney. It's going to be valid while you're incapacitated, but the moment you pass away, that durable power of attorney is no longer valid. What do you need? A will or a trust. That's what you need. All right, my contact information is there. I'm going to put it in the chat as well. I'm going to stop sharing my screen and I'm going to finish answering your questions. So give me just 1 second. Okay, I see some questions here too in the chat, but let me go ahead and put my contact information there. All right, there is my contact information. Here is my website. Here's another one of my websites that I recently created. I hope you like the cat. All right, so let's go back to Q&A. How can one find out how title is held? Look at the deed. Every county, depending on where the property's at, has a copy or should have a copy of the last recorded deed. And in the deed, it will tell you who's on title and how it's titled. So yes, you can get the deed from the county. Is it best to title investment property in a land trust or an LLC? So a land trust is a way to hold title. It allows for anonymity. It's used for property, but it doesn't give you liability protection. A limited liability company does give you liability protection. That's a very important distinction. So if you're looking for liability protection, I would say title investment property in the name of the LLC. With regards to the question about the disability check, you said earlier that the person has to be on sound mind. However, I know several persons that collect disability checks and are caring for their children. So my question is, if they pass, and will the will be valid? You can be on disability and still have sound mind. What I'm talking about is mentally disabled. You need to be of sound mind when you execute the will. If later you become no longer of sound mind, that's fine. Also, the law has something called, like you had sound mind or a split second during that time that you executed the will. That could happen too. There's some people that have mental problems, but they're able to be of sound mind during a specific period of time, and then later they're no longer of sound mind. As long as they executed the will when they were of sound mind, you're going to be okay. That's what the law looks like. If there is a will there still be a probate process? Yes, a will gets probated in the probate court. A trust, the assets held in the trust are not subject to probate. Okay, now we still have to notify the court when you pass, and it's a process that we need to do, but the assets that are held in the trust are going to be managed according to what the trust says. Okay, somebody's asking me for costs. I will pass that on and send it. Okay, great presentation. Thank you. How long does the probate process generally take for a property to be sold? That's actually a great question. I recently bought a property, and I didn't know, but the person had not started the probate. So it was a property I was buying for myself, and I really needed it because I wanted it for my puppies-in-law so they can live close to me. I told the seller, listen, you need to open up a probate. He had the will. He thought he was all good. And I said, yes, the will is all dandy. It says that you get it. But unless you open a probate, guess what? You cannot sell the property. So I explained this to them. So I said, I can open up the probate. It's going to be quick. And it literally was. In 2 months, we were able, no, a month and a half, 2 months, a month and a half to 2 months, we were able to get the court order in order to be able to sell that property so I could buy it. That's a good scenario. It was homestead property. The heir was only him and his brother. The will clearly stated that. Boom, it was done. However, that's not always the case. If you open up another probate and it's not just one property, it's many assets, then it may take longer. If you open up a probate and people start fighting about it, you know, no, it's mine, no, it's not. It may take longer. So to answer your question, how long does a probate take? It depends how good the attorney is. I would say choose us, we're fabulous. And also what property is there and are they gonna fight about it or not? Assuming everything goes well, you know, it could be fairly quickly if everybody cooperates. And you have the will, right? So the will has to be the original will, so important. And the will has to be executed according to Florida law. And there's something called a self-proving affidavit, okay, that's put as part of the will. If your will has a self-proving affidavit, then we no longer have to chase the witnesses that were there. If the will doesn't have a self-proving affidavit part, then now we have to chase the witnesses. And if the witnesses died, it becomes more complicated. So hire a good attorney to draft those documents, hire an even better attorney to do your probate, and you can hire us for both. This is what we do to make sure that it happens. And we're also title company, so we know how to get closings done. You know, we do closings through our firm all over the state of Florida. So we're dealing with probate all the time, and investors that want to acquire a probate property, so we know how to handle that. All right. Let's see what other questions I have. Is there an opportunity for overbids as part of the probate process in Florida? I'm not sure what that means. Okay, I will send you guys my package on costs. In case both parents die, what if parents choose to appoint grandmother and grandfather who are not residents in the U.S. and live abroad to look after the children? I mean, your children would have to go abroad. Being appointed as a guardian, we handle immigration too, and being appointed as a guardian of minor children doesn't give you legal status to come live in the United States. So if you're appointing somebody that doesn't have legal status to live in the United States as your guardian for your children are going to have to go live there, you know? So be careful with that. Think about those things. For Medicaid, that's a very complex question. We do have an attorney that focuses just solely on Medicaid, so we can have you meet with a consultation with them for Medicaid planning and how that works. Can you please explain the difference between revocable and irrevocable trust? Sure. So revocable trust is the trust that we've been talking about to now, right? So you make a trust, it becomes irrevocable when you die. Not now, you can keep on making changes. An irrevocable trust becomes irrevocable, like the word says, at the moment that you execute it. It's written on stone. You can no longer change it. Whatever you put in the irrevocable trust is no longer part of your assets. You no longer own it, and you cannot decide what happens to it either. So if you're doing an irrevocable trust, it is so important to name a trustee you trust, which is the trustee is the one that administers the trust, and for the trust to lay out exactly how the trust should be administered to the T. So there are no questions, so that your will or what you want to happen actually happens. So it's very important when doing an irrevocable trust, again, that you fully understand the document, that your attorney fully understands what you want. And a lot of times, irrevocable trusts are done in order for you not to own the assets anymore so that you qualify for Medicaid. Medicaid has a look-back period of 5 years. If you try to plan for Medicaid and you need it in the next year, 2 years, 3 years, 4 years, 5 years, not going to happen. Because they can look back and say, you did that to get Medicaid, now you're no longer qualified. So if you're thinking about those things, it's important that you plan ahead. It's always good to plan ahead because you don't know when you might need it. All right, so that's revocable versus irrevocable. Somebody's asking me, do you provide documents when a revocable trust is completed by your firm, like our chip or USB that has all the information? We can give you a USB, but the original documents, it's very important that you put them in a safe box or somewhere that's going to be protected, because the chip and the stuff might help, but not really. You need the original will. So you want to make sure that you keep them in a safe document. Okay, let's see. Somebody's asking me, do court confirmation sales require legal publications in Florida? I'm actually going to ask our probate attorney. I'm going to message her right now. I guess you mean when property sold in probate. Let me see if I can get you an answer right now. I'm asking our probate attorney, but if I don't get you an answer, please email me. So she's asking court confirmation sales. What is that? Marisol, if you want to rephrase that question or email it to me, I'll make sure to answer it or have my probate attorney answer it, because we're not sure. If you mean sales approved by a court, let's say you mean that, I'm going to ask her if we need to do that. Then no, she's saying it requires no publication. All right, so let's see. Any more question? My dad passed away several years ago. He was remarried, but there were 5 children prior to the marriage. We were not notified of any other assets from the previous wife. Is there a way to find out anything about it? My dad used to own a few properties. Hire an investigator. We have no way of knowing where the assets are unless we drafted the probate documents and put in, I'm sorry, the estate planning documents, and the client told us where the assets were. We have no way of knowing where. It's not like a database that we can put the person's name and see, okay, these are all the assets the person has. You have to do an asset search. You have to hire an investigator to find out. Going back to Marisol on the publication question, she's telling me the publication is done when the decedent has been dead for less than 2 years. If that answers your question. If it doesn't, please email me. All right, I'm going to put my contact information here again. I already see emails coming up from you guys, which is great. This is my phone number. This is our website, so you can visit. So our websites are www.jflawfirm.com, and then my new website, which is basically my name, www.romijurado.com, and it has a nice kitty on the first page. Thank you so much for having me here today. I really enjoy spending time teaching you guys. I wish we can do this in person soon when this COVID devil is over. Until then, please, keep on seeing us as a resource. We keep on having classes coming up. We love to collaborate with the Board of Realtors. They do a fabulous job of keeping you guys informed. So if there's anything that I can do, please reach out to my team and I will follow up with the webinar recording if it came out good, and I will for sure send you guys the slides, and I'll send you some pricing and whatever else you required. Thank you so much. Have a beautiful rest of the week and a nice weekend. Bye-bye.